This is Michael Popok, Legal AF. Without even stepping into the courtroom again, without even facing a jury trial or making a decision whether to testify, Donald Trump has already lost for the second time against editor, journalist E. Jean Carroll for what else? Defamation and ultimately punitive damages. E. Jean Carroll, as you may remember, back in May, got a jury verdict in her favor where they found that she was, in a civil case, sexually abused by Donald Trump and defamed by him and awarded $5 million. On this past week's edition of Legal AF on the MeidasTouch Network, Ben Meiselas and me get right under the hood, take that flashlight, and break down for you why Judge Kaplan, federal Judge Kaplan in the Southern District of New York, just ruled that Donald Trump is not going to get another shot at trying to convince a jury that he doesn't know E. Jean Carroll, never met her, not his type. She's a hoaxer trying to shake him down because, as you'll hear, what he did about her in 2022 and all the bad statements he made about her, which the last trial was about, is identical to what he said about her in public in 2019. So why have a trial? All right, let's find out. Let's go to Ben and me breaking down why there's not going to be a second trial and E. Jean Carroll's already won.
Where Judge Lewis Kaplan granted E. Jean Carroll's motion for summary judgment. This is the E. Jean Carroll 1 case that was filed in 2019, the E. Jean Carroll 2 case that was filed in 2022 regarding Donald Trump's defamatory October 2022 statements, as well as the fact that there was the Adult Survivors Act, which allowed cases for sexual abuse to be brought after the statute of limitations in New York for this 1 year period. Those were the claims brought in E. Jean Carroll 2 in 2022. That case went to trial, jury verdict, May of 2022. Donald Trump was found liable. But Popok, that decision, that jury verdict, that finding, right, something called collateral estoppel, and that $5 million jury verdict had implications on the judge's order. Explain that, and how big is this? So, like, what's this trial going to be about?
Big news. Donald Trump has already lost his second trial against E. Jean Carroll before it even started because the judges ruled as a matter of law and as a matter of a doctrine that we'll do a little teachable moment here called issue preclusion or collateral estoppel. That which already happened impacts what was going to happen. In other words, you don't get a second trial to try to convince a second jury that the almost identical defamatory statements that you made against your victim, that she's a hoaxer, that it never happened, look at her, I would never do that, she's not my type, as if there's a type for rape. All of those statements, it's a shakedown, that were identical to the statements that were already tried by a jury in New York. He's not going to be able to try to convince another jury that very exactly the same or virtually the same statements that were made in this case in 2019, almost identical to the 2022 statements at the heart of the May jury verdict. It's hard to believe we talked about it at the top of the summer, and now we're here after Labor Day. Because you don't get that right under two different concepts in the law, because we don't waste scarce judicial resources and jury time to try a case that's literally already been tried. And that's what that's what happens to you as a defendant if you've already lost once and you have to. Another reason he should have probably testified, but didn't. So let me explain quickly. In the E. Jean Carroll case that went to trial, that went to jury verdict in May, it was all about the statements that Donald Trump made in 2022 after he was president that were all along the lines of what I just said. There's a series of things that he said, denying he knew her, denying that he touched her, calling her a hoaxer, a fraud, shakedown artist, and the like. And the jury also had to determine in that trial whether she had been raped, sexually abused, or something akin to that under New York criminal law. That jury already decided that all of those statements were defamatory and done with malice or actual malice because they also found in the same breath that she had been sexually abused. They were this close to finding that he had raped her under a very specific technical definition of rape under New York law that requires a penis be involved and not digital rape, which is what she was able to testify to, that he put something else inside of her. There's no other way to put it. And the judge, whenever he writes about the case, reminds Donald Trump that the case was about rape and that he was technically found guilty of rape no matter what he says. Because Donald Trump has tried and failed, for instance, to bring claims against E. Jean Carroll, the victim, claiming that he's been defamed because he didn't rape her, he sexually abused her. And the judge said, it's the same thing. And your case is dismissed. And that happened about a month ago. Here, the judge said, let me look at the two sets of statements. The 2022 statements that the jury already found were defamatory, having found that you sexually abused her or raped her, as he said in his order. And let me look at it and compare it to the 2019. And we may not even have to have a trial at all. Let me see. And he said, you know what? They're almost identical. And we have a word for that. When something has been tried involving the same parties on the same issue, we have a word for that, a doctrine for that under law. It's called issue preclusion, or what we used to call collateral estoppel. And that means you can't litigate again. You're precluded from litigating again that which you've already lost on from an issue basis. There's also something in the law called claim preclusion, where if you have the exact same claim against you, breach of contract, some sort of tort, you can't litigate that either. That's usually called res judicata or claim preclusion. But here we have issue preclusion, the issue of the defamatory statements. And the judge said there's two reasons you're not going to get another trial, and I'm going to fine for the plaintiff, E. Jean Carroll, again on her second defamation case for you, leaving only the amount of check that the jury is going to force you to pay in damages left for a future trial. That's the only trial you're going to get. And he said, the other reason I'm going to do it is, one is issue preclusion. The other is we have a standard in federal court for summary judgment, which says that if as a matter of law on an undisputed factual record, there are no facts in dispute, I'm going to apply to the law and find as a matter of law that that's defamatory, given the guidance I've already gotten from the jury in May. And so he said, all right, there is no dispute of the public statements that were made by Donald Trump. He could quibble, which Donald Trump did in his briefing about, well, what I meant was, but it says what it says. He made statements on his social media. He made statements at rallies and in interviews. They're all public, and that's undisputed. And on that undisputed factual record, the judge says you lose for another reason, because I'm going to find as a matter of law, which is my right, I'm going to find that you committed defamation again with actual malice. And then Trump tried to move for summary judgment, because why not? He's there. And he asked to have at least a credit for the amount that he hasn't yet paid, but the jury awarded her for $5 million. He wants a credit because the new defamation would overlap with the old defamation, and he should get a credit. And the judge says, I'm not doing that. The jury is going to hear the evidence concerning the injuries that she suffered and the defamation amounts put on by, I presume, an expert, and E. Jean Carroll testifying, and they'll be the judge of literally of what the amount is that they're going to award you. So the end result is there will be a trial. I don't know when, given the fact that he's going to trial in criminal and civil cases 7 different times in 9 months, but somewhere in the near future, there's going to be a trial of Donald Trump where the jury is going to be told after that they are selected and during the selection process that the judge has already ruled that Donald Trump defamed E. Jean Carroll. You are to assume, for the purposes of your deliberation on the amount of damages, that you are to assume and to find that there has already been a defamation. The only thing left for you to do is determine if she's been damaged and by how much, how big of a check. That's it. And the jury's going to go, well, that's easy. And then you've got a smaller group of witnesses. You got E. Jean Carroll. You've got psychological experts like she did in her first case. And you've got probably an economist who's going to talk about the damages. And then they're going to go for punitive damages, which is that category in our society of punishment damages that aren't necessarily tied to the actual damages suffered by somebody, which is done based on how much money they have, right? Mr. Braggart up the street at the Attorney General's case by Judge Engoron, bragging about the fact that his personal wealth is even greater than the Letitia James is arguing in that case, great. Because the bigger your wealth, the bigger the punitive damages have to be in order to make you suffer. Because if a jury says 100,000 in punitive damages and you're worth 5 billion, that doesn't mean anything. You're carrying that around as pocket money. So they have to know how much your net worth is. This is going to be fun during that trial. When Donald Trump, who used to brag about his net worth, is now going to shrink before the jury and say, well, I really don't have as much money as I said I had, because he's going to try to shrink the punitive damages. But that's what's going to happen in the near future. Another win for justice, another great win for Robbie Kaplan and her client, E. Jean Carroll.
E. Jean Carroll's lawyer, Roberta Kaplan, is going to take that deposition that Donald Trump was just released in the New York Attorney General civil fraud case. That's going to be evidence in the punitive damages as it relates to Donald Trump's net worth. E. Jean Carroll's lawyer is going to take this briefing as Donald Trump is boasting and frankly lying about the amount of money he has. But E. Jean Carroll's lawyer is going to say, look, here's what he claims that his net worth is. And that's actually one of the considerations that are done when it comes to a punitive damages assessment. Also, recall that E. Jean Carroll and E. Jean Carroll's lawyer amended this complaint to add the fact for purposes of punitive damages that after Donald Trump was found liable for sexual abuse and defamation in May, he did that so-called CNN town hall, and then thereafter continued to defame E. Jean Carroll, which goes to the importance of punitive damages here. I think that E. Jean Carroll's lawyers are going to ask for somewhere in the range of $10 million in compensatory damages. And then I think they're going to ask for somewhere in the range of $50 to $100 million in punitive damages. And I think they're going to say to the jury, look, this number may seem high, but the law says that it should be consistent with the net worth of an individual. And we hope, this is what E. Jean Carroll's lawyer is going to say, and it's going to be so powerful. Roberta Kaplan's going to say, we had hoped that after we prevailed in the first trial, that she could just go on with her life and reclaim her name and reclaim her reputation. We weren't even considering that we were going to have to be here. But then immediately thereafter, Donald Trump went on CNN in front of millions of people. They're going to get data also that shows that not only was it viewed millions of times by CNN, by people watching CNN, but also the amount of impressions and views will be in the hundreds of millions. Hundreds of millions of people saw Donald Trump make the same defamatory statements about her. The purpose of punitive damages, ladies of the gentleman jury, is to punish, to stop this behavior. The only way we can stop this behavior is if you hit him where it hurts, which is in the pocketbook. And so we're going to be requesting $100 million. I think that it'll be very similar to that. Yeah. Mark the tape. We will see what that argument is. But Popok, I want to talk about.
I just want to say one thing, just one thing. I like the $100 million number. The only thing I think it's limited by is, there is a body of Supreme Court precedent, U.S. Supreme Court precedent on punitive damages being a certain multiple of the actual damages that are awarded. And when it's not, so I'm not sure they're going to give her, I agree with you on the 10 million, by the way. I think it's 10 or 15 million in the actuals. Even with, him arguing that there's an overlap between the prior, even though he's not going to get a credit for it, the prior payment. But, so maybe it's only 3 or 4 or 5 times that. It's still $50 million. I'm just not sure they're going to be able, under the Supreme Court precedent, get a 10 multiplier on top of actuals. But it'll be a huge number, and it'll be the right number because, E. Jean Carroll can never recover what she's lost. I mean, she testified in her trial that in the ensuing 30 or 40 years, she has not ever had she's never had a romantic relationship with a man after what happened to her in that dressing room.
Yeah, it'll be interesting to see, that there's, of course, the BMW of North America, Inc. v. Gore case was the case that you referenced by the Supreme Court, 5 times, 10 times, what that multiple will be, it's going to be up there. It's going to be a significant number, though, and we'll keep.
That's a fascinating result. This is stuff that Ben and me learned years ago, at least for me, in law school. the application of the collateral estoppel or issue preclusion doctrine combined with kind of basic summary judgment law under Rule 56 of the Federal Rules of Civil Procedure, which when I learned about it, I kept my eyes open, but it was difficult. But now when you see it in action, a former president loses his opportunity to try again in front of a second jury and has already been adjudged on summary judgment right now that what he did in 2019 being basically identical to what he did to the E. Jean Carroll in 2022, his victim, that he doesn't get another trial. And the only trial that's left is how big of a check and punitive damages. I mean, I would have stayed up. I would have stayed up longer in my law school classes had I known it was going to be that exciting. And we try to make the podcast exciting. We do it on Wednesdays and Saturdays only on the MeidasTouch network. It's a free subscribe. Help them get to 2 million on YouTube. And then we put our Wednesday and Saturday editions of the Legal AF podcast, which is about 5 of these kind of stories. We put together long format. You like these kind of hot takes? You're going to love the regular podcast. On Wednesdays, I do it with Karen Friedman Agnifilo. On Saturdays, I do it with Ben, just like you just saw. And then we put it on audio everywhere you get audio podcasts from, Google, Apple, and Spotify. And we're regularly ranked in the world in the top 50 for podcasts related to news. It's amazing. Even I'm amazed by it, and I help put the show together. So until the next hot take like this one, it's Michael Popok for Legal AF.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.